welcome everyone. I will start with a case. It's a decision of the District Court of Mannheim from April last year. And this decision here deals only with the requests of the parties to have specific information protected during the proceedings. So it's not much history here on the negotiations of the parties or on offers and counteroffers that have been exchanged in these proceedings. The decision focuses on this one particular topic: should there be protective measures granted or not? And the court indeed provided some measures or qualified certain information as being worthy of protection in the present case, but also to a certain extent refuse to qualify other type of information and order protective measures for this type of information. And as we're going to see in a moment, the main reason for that was that there was an NDA between the parties signed before the proceedings, which was also enforced during the trial. Before we go into the details here, I think to add some context, some very brief overview of what is the status quo in Germany regarding the protection of confidentiality in court proceedings, in civil proceedings. There is one important act that has been enacted in Germany some years ago, which is the Trade Secret Protection Act. And this act goes back to a directive from the EU, which was then transferred into German law, and offers a framework to protect trade secrets in civil cases. And in a nutshell, how this works, it is a two-step approach here. So on the first step, the parties can designate specific information they want to put under protection, and then the court decides whether to classify this information as confidential or not. And when this happens, this gives rise to certain obligations for the parties to the proceedings, so the claimant and the defendant, but also to third parties that are involved in the proceedings, for example, witnesses or experts, to keep information that has been qualified as confidential, also confidential during the proceedings, but also after the proceedings ended. And this can go so far as preventing the court, for example, to share the court files with third parties after the end of the proceedings, as far as confidential information is included inside in the briefs and the documents. But also there is a possibility to have also additional measures taken by the court, for example, limiting access to the documents that are confidential to a specific number of people, or maybe excluding also the public from oral hearings during the proceedings. This is the framework which applies to trade secrets. And this framework also applies now after the recent reform of the German Patent Act in patent infringement proceedings. There was one provision there in the law which came into force a couple of years ago, the new Patent Modernization Act, which basically just provided that this framework for protection of trade secrets in trial is applicable also in patent cases as well. One of the reasons why the lawmaker decided to do that was also were also front cases where the lawmaker indicated that there is a specific need to protect confidentiality in this type of proceedings, also with respect, for example, to comparable agreements that need to be disclosed in the proceedings, etc. So this is the framework here under which the court made its decision. The question was here whether this framework, which is for trade secrets, applies also in the present case, in this patent infringement proceedings that we have here, or whether this is not the case. And as I told you already, what was particularly interesting in this case here was that the parties had signed an NDA before the proceedings that covered certain type of information and was still in force during the proceedings. And the second interesting element here was that apart from the NDA, the parties also agreed that if there would be a trial, they would disclose confidential information only under court-ordered protective measures. So they would disclose information in the proceedings only when if the court would order measures to protect confidentiality if the information is sensitive. Against this background now, as I said already, the court found that to a certain extent, and especially to the extent to which information was covered by the NDA between the parties, there was no need to order protective measures here in the present case, and respectively denied doing so to the extent that the information was covered by the NDA. The reason for that was basically that the court found that in this scenario, the parties did not have a legitimate interest to request protective measures. This legitimate interest is, let's say, a very basic condition to have access to any type of legal protection by courts. And the court found here that as long as there is an NDA between the parties, there is no real need to have also court-ordered measures applied in the present case. So why is that? The court found that the reason why you would order protective measures, which is basically to allow a party to have effective legal protection, meaning allowing a party to plead and to disclose confidential information in the proceedings in order to be able to build its case and plead its case successfully, is served also by an NDA here, because this would allow the party, at least towards its opponent in the proceedings, to use this confidential information, so that the NDA would also exclude a risk to lose basically the trial due to a failure to disclose information which are confidential. And since the NDA would basically make sure that this is the case here, the court believed that you don't need also court-ordered measures that would do more or less the same thing here, because the NDA would suffice in this regard. So this was the main reason why the court found there was no need to have protective measures in the present case. Around this question whether there is a legitimate interest or not, there was one topic discussed, which was, is there maybe a need to look things differently here, because we had this agreement between the parties that they would disclose information in trial under court-ordered protective measures. So would this agreement between the parties change things here and maybe create a legitimate interest, which would then justify having protective measures despite the fact that you have an NDA here? And the court found that this is not the case. It basically said if you have whether you should grant protective measures is something that the law, the statutory conditions have the say on, and if these conditions are not met, then the parties cannot modify by agreement basically the conditions for granting protective measures to protect confidentiality in proceedings. This means also, according to the court, that if a party gets trouble in the proceedings because due to the lack of court-ordered protective measures, they cannot plead the case as they would like to, and they would face problems with their evidence, this is something that is not concerning or does not really justify looking at things differently here, because then the regular rules of civil procedure apply. And in Germany, this means that the party that needs to present and plead and also disclose information, if they fail to do so, then they take basically the burden for that failure. So here the court was not satisfied that this agreement between the parties to have production of documents under court-ordered measures in the proceedings could create this legitimate interest and allow the court to take these protective measures. What was interesting here was, however, a question which is very important in this context, and this is the question: what happens with protecting confidential information towards third parties? Because the NDA can, of course, offer a level of protection, but the NDA is an agreement between the two parties to the proceedings, the claimant and the defendant. And others that might be involved in the proceedings are not bound by the NDA. This is clear. And one argument was here that because of that, because of the fact that the NDA does not extend to other parties, you need to have protective measures nevertheless granted by the court here to make sure that also confidentiality is kept towards third parties. The court said that this is not the case and argued basically by saying that the Trade Secret Protection Act, again, we said all of this framework is derived from this specific law. The primary aim of this act is to protect confidential information towards the opponent, not towards any third party. And to demonstrate that, the court mentioned that if there are protective orders taken by the court, then only the opponent has the possibility to contest these orders by the court. So not other third parties, only the opponent can do that, meaning then vice versa, that it is basically only the opponent who is a target of this type of protective measures, not any other third party. Of course, as we have said already, if information is classified as confidential, then this is, as the law stands today, this bounds also third parties that might be involved in the proceedings, for example, witnesses or experts. So there is already in the law some protection towards third parties, but the court found here that this is not the main purpose of the law, and that this protection towards third parties is just a reflection, as the court put it here, of the primary objective, which is to protect confidential information towards the opponent in the proceedings. Meaning again that just the notion or the need to protect information towards third parties is not sufficient to justify protective measures in the eyes of the court here. In this context, the court added that you should consider as well that third parties might be also bound to some confidentiality, to keep some information confidential by other type of rules, for example, administrative rules or penal rules, so that there is at least also towards third parties some level of protection of confidentiality. So in general terms, what the court concluded here is that the need to protect confidential information in trial towards third parties does not justify granting this type of measures in the specific case. Then the court looked at the specific setting here. Here, of course, we have a patent infringement trial, a front trial, so we're not talking about trade secrets. And the question was, has the Patent Act, which refers to the trade secret framework, provided for a stronger confidentiality protection, meaning including third parties or not? And the court said here that this is not the case, because it said this is just a reference to the framework under the Trade Secret Protection Act. So the standard of protection is under the same conditions as the Trade Secret Protection Act, which means that in front trials, as we have here, if an NDA exists, then you will regularly will not have a legitimate interest to request protective measures for confidential information. And in the eyes of the court, this is also not a problem, because as we have seen already, the court believes that the NDA in this case would provide for a sufficient and effective legal protection in front cases, because at least towards the opponent, you would be able to use confidential information in trial. And the fact that third parties are not covered by that in the eyes of the court does not impair the objectives followed by the new Patent Act. So here, the court basically said there is no different treatment, or let's say a stronger protection or a higher threshold when it comes to patent infringement cases. The same things apply as in trade secret protection cases. So having said that, the court, as we have seen, denied giving protection or ordering or classifying some of the information requested by the parties here as confidential. What was then interesting was that the court made some remarks regarding the scope of the protection here under the existing framework, and especially what type of information could, in general, be subject to such protective measures. Here, of course, the caveat, this is not a final decision of the court. These are some remarks of the court, basically some ideas that the court wanted to express here. It did not decide on the scope of protection in front cases itself here, because it had already dismissed such measures by saying that there is no legitimate interest. But nevertheless, I think it's interesting to take a look at some of the way of the remarks of the courts, because I think they indicate a little bit a direction that the courts might take regarding information in front cases. Here, the court said that if you look at the licensing terms that the patent owner has requested from the implementer, or has offered to the implementer, or you look at information needed for the assessment of the front conformity of an offer, which might include, for example, also comparable agreements, then whether these type of information will be worthy of protection under the current framework appears in the eyes of the court to be questionable. And in any case, it would require particular justification in individual cases. And why is that? In the eyes of the court, this is the case because in front cases, it seems in the eyes of the court to be a need to have at least a minimum level of transparency regarding the licensing conditions. And where does this come from? The court found that this comes from the front commitment of the ACP owner towards the SDO. Also, it can be extracted from the fairness element of front, and potentially also from competition law. So here the court did not basically exclude that the licensing conditions that were offered to the implementer, or maybe other confidential information, third-party license, etc., could be subject to protective measures. It, however, seems to take the view that the respective threshold would be rather high in front cases. So we're going to see, of course, how this evolves, but it's interesting to see this at least preliminary view of the court here, which is in the direction that in front trials, protection of confidential information, of licensing terms, etc., seems to be rather difficult, or the court, or you will need to have a particular justification to be able to protect this information through court ordered measures.